It's time to talk about serious criminality. In Canada, there are two types of criminality: general criminality and serious criminality. We discussed general criminality in our last video. Go check it out if you haven't already. Unlike general criminality, serious criminality will make foreign nationals and permanent residents inadmissible to Canada if any of the following apply. First, they are convicted in Canada of an offense under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years, or of an offense under an Act of Parliament for which a term of imprisonment of more than 6 months is imposed. See the difference there? 2, they're convicted of an offense outside of Canada that, if committed in Canada, would constitute an offense under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years, or 3, they committed an act outside of Canada that's an offense where it was committed, and that, if it were committed in Canada, it would constitute an offense under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years. That's a lot, so let's splice it and break it down. Right off the bat, all three grounds of serious criminality contemplate indictable offenses only. If you committed 2 or more summary offenses, serious criminality will not apply to you. And again, all grounds for serious criminality talk about acts of Parliament, so if it's not a crime under federal legislation in Canada, it's not going to result in serious criminality. Check out our video on general criminality to learn about the 3 exceptions to that. So, the easiest way to understand serious versus general criminality is by looking at what the possible prison sentence would be if the crime were committed in Canada. What's important to emphasize here is that the possible sentence that could be imposed under the criminal code is what's looked at, not the sentence that's actually imposed. So if the crime carries a potential maximum sentence of less than 10 years of imprisonment, it's considered general criminality. Crimes that are non-violent are generally in this category. Serious criminality is assigned to those crimes that are punishable by a prison sentence of 10 years or more. Many of the crimes that are going to fall into this category will be violent in nature or involve a weapon. Here's an example to really nail the point home. Jane is a Canadian permanent resident, and she's lived in Toronto for about 1.5 years since getting her permanent residence card. Jane was involved with a robbery, and a weapon and threats were involved. She was ultimately charged and convicted of aggravated assault. Aggravated assault carries a potential term of imprisonment of 14 years in Canada, but Jane was only sentenced to 8 years. Jane is now facing a serious issue. Since she was convicted of serious criminality, she is inadmissible to Canada. She's now at risk of being deported, even though she's a permanent resident, and even though the term actually imposed was less than 10 years. I hope you caught that. It's important for everyone watching to understand that DUIs are considered to result in serious criminality in Canada. As a result of Bill C-46, passed in December 2018, which is around the time the Government of Canada legalized recreational marijuana, the maximum penalty for impaired driving was increased from 5 years of imprisonment to a term of not more than 10 years. Impaired driving is also a really good illustration of the rule that the penalty in force at the time of the commission of the offense would control the criminality determination. This was confirmed by the Supreme Court of Canada in Tran v. Canada. So, if a person committed the impaired driving offense before the law changed, the more lenient penalty of 5 years applies. This means they would be inadmissible for general criminality, but not for serious criminality. Now, if the offense was committed after the law changed, they would be inadmissible for serious criminality, so permanent residents would be affected as well as foreign nationals. Let's use John as an example. John is a sales manager in Illinois, and his company wants him to attend an industry conference in Toronto to promote their products. This is the preeminent conference for professionals in John fields, and it's really important that he attends. However, in December 2019, John was pulled over by a police officer in Illinois when driving home from a Christmas party. He was charged and convicted of driving under the influence, and it was charged as a misdemeanor. But even though it was a misdemeanor in the US, John's not going to be able to come to Canada for that conference. He is inadmissible due to serious criminality. His only option is to try to obtain a temporary resident permit in order to enter Canada temporarily. So, beyond the impact of foreign nationals versus permanent residents, why do we really care if the offense is general criminality or serious criminality? Well, it's also going to impact the availability of remedies. In our next video, we will talk about criminal rehabilitation, deemed rehabilitation, and temporary resident permits. If you'd like more information on our criminal and admissibility services, check out our website at www.cisulegal.com.